Hey everybody, this is Chris Addick coming to you from the Veterans Law Blog live on Facebook. It is Friday, October the 21st, and wanted to tell you, first of all, I have no idea how long this thing is going to go. I have planned probably about 40-45 minutes worth of talking. Going to cover some great topics here today, but the big news is this disruption of internet service that kind of swept through the East Coast, knocking out sites like Twitter and PayPal, and so nobody knows who's responsible for it. But the bottom line is that at any time our service could go down. So we were actually out here for a good bit of the morning. So if you were trying to reach me, I had to move to another site and wasn't able to really function fully in all the work that we're doing. But anyway, we're here today to go live on Facebook, taking your questions. Listen, I solicit questions by email. So if you're a subscriber to one of my email lists, then you got an email asking for your questions for the Q&A today. And I got last week over 100 questions. This week I got another 100. It's got some great questions from y'all. So problem is we only have a limited amount of time to address them all. So what I did is I picked the questions that seem to be most commonly asked throughout all the list. And some of those questions we're going to address in full-length videos later down the road. Some of them require a little bit more preparation. There was one question about CIA records. That's going to take a little bit of work to put together. But in any event, thank you for the suggestions. If you have them, shoot me an email and let me know any topics that I could cover. Any Dodger fans here in the house? Going once, going twice? No, there are no Dodger fans. All right, so that's a good thing. I don't have to complain about Joe Blanton again, hanging another slider up in the zone there. Miguel Montero goes yard in a grand slam in Game 1, and now Addison Russell did it last night. So it's all down to Clayton Kershaw. So hopefully the Dodger fans are pulling for them, and if not, I guess we'll see the Cubs in a World Series finally. So, in any event, let me tell you a little bit about the Veterans Law Blog. The Veterans Law Blog has been published since 2007. I teach veterans how to cut through the fog of their VA claims and appeals, and I do that by teaching you the practical tips and tools that you need, as well as the basic understanding of the law of the VA claims process. That information is available. There's over 1,000 posts, over a dozen books, training manuals, and videos that are available on the blog. Some of them are free, some of them are available for purchase. But the Veterans Law Blog is membership supported. So all this is not possible unless you join as a member. So without the member support of the blog, this blog could no longer exist. It's simply too expensive to keep going. So I would encourage you to sign up for a membership. There's 2 levels. Premium memberships can be monthly or annual. So you can either pay, I think it's currently $99 a year, and then there's a smaller monthly incremental if you want to go month to month. If you sign up, you get the first 7 days free, so take a look at it, see if it's something you like, and if you don't like it, just cancel anytime. No hard feelings. You won't be charged if you cancel within those first 7 days. A lot of folks ask me when they sign up, like, where do I start? Getting into this whole mix of improving my VA claim. And there's a post I'm going to put in the show notes called the 8 Steps to Improving Your VA Claim. So I've looked at thousands of claims files over the years. I've handled cases for a very large number of veterans, both at the court, the board, VA regional offices around the country. And so I've looked at a lot of C files, and I've gotten to see a lot of the things that we veterans do right and do wrong in our claims and appeals and how we can improve them. And I broke that down into an 8-step process that I think anybody can apply. I'm going to put a link to that post so you can see all 8 steps and work through that process. And we're hoping to have some more webinars on some of those topics coming up. If you stick through to the end of this video, there's going to be some discounts and coupon codes that I'll share with you for premium membership so you can save a little bit of money. But you have to suffer through about 45 minutes of me talking to get to that. So in any event, quick legal disclaimer. I got to do this. I'm a VA accredited attorney, and there are rules and requirements that I have to follow. So I've got to tell you that nothing can be better than the advice of an accredited VA attorney. No blog post, no video, no book, no nothing, not even me talking on it. Even though I'm an attorney, I'm talking generally about VA claims process and law. I am not giving you legal advice in this video. Nothing is better than getting advice, legal advice about your specific claim and your specific issues from a VA accredited attorney. So I just want to cover that real quick. The big news of the week is the Gulf War presumption was extended. So what does that mean? December 31st of 2016, the presumptive service connection rules for the Gulf War syndrome, or what's now called chronic multi-symptom illness, were set to expire. And the VA went ahead and extended those through to December 31st of 2021. What does that mean? Essentially, if your symptoms of this condition or cluster symptoms of these conditions did not present themselves by December 31st of this year, you were going to lose the right to file a Gulf War service connection claim. Now with it extended out to 2021, you have a lot more opportunity to do that. So, all right, let's see. There's a piece in the Stars and Stripes that really walks through this very well. I'm going to link to it in the show notes, and you can read all about it there. I'm also going to put some stuff in the show notes about Gulf War presumption claims and chronic multi-symptom illness claims so that you can get a good basic understanding of how those works. It's kind of a complex presumptive service connection claim, so I want you to read through that. One of them is a video blog, the other is a written blog, and I want you to watch and read and get a better feel for how those claims go. A lot of veterans do these wrong. It's really important to do these claims right because the VA currently is denying about 80% of them. I'm not saying that's veterans' fault. It's not at all. I don't think the VA even understands their own regulations. In fact, I know they don't understand their own regulations. But bottom line is, what I want you to do is become very familiar. If you've got a Gulf War presumptive claim, I want you to become very familiar with those presumptive service connection rules so that you can put your best foot forward in making a claim and hopefully not have to appeal. In any event, next week we got some great posts coming on the blog. I'm going to review 3 court cases that came out here in the month of September. They're not precedential, they're just single judge decisions. Basically that means that they are binding on the VA, but they can't be cited as precedent. And so these cases relate to things like 100% ratings for PTSD, proving the incurrence of a military sexual trauma or an assault in service, how to corroborate that, not a unique way, but the court just strengthened one of the ways that I think is really going to be advantageous for those that are making a service connection for a condition related to a military sexual trauma. And then finally, we're going to talk a little bit more about this concept of extra scheduler ratings. It ain't TDIU. It's not that at all. This is kind of a newer concept that's been developing over the last 3 to 4 years. Frankly, I personally think that it's going to really change the whole texture about how the VA handles claims. But stay tuned next week. We're going to talk more in detail about that and get into 3 really, really powerful court decisions, I think. Stay tuned, become a member of the blog, and you'll get notified of those new posts right away. Or look for the links here on Facebook, and I'm going to post them. All right, so as I mentioned earlier, a lot of questions came in. A whole ton of them, in fact. And so I wanted to address a couple of them real quick because some of them were really, really good questions. But the problem is I can't cover them in a short live Facebook video here on a Friday afternoon. So I'm going to the drawing board. I'm doing a lot of research. I'm putting together some real solid information. John didn't leave his last name, but he had some question. How do you prepare for a BVA hearing? That's really important. That's a really good question because the BVA is the last step in the administrative claims and appeals process. And if you don't have stuff in the record by the time the BVA makes that decision, if you're denied, you don't have the opportunity to supplement the record at the court. The Court of Appeals for Veterans Claims is not a fact-finding court. All they can do is look at what the BVA did and say, yep, they messed up. Nope, they didn't mess up. That's basically all they can do. Now, frankly, it helps that 75 to 80% of board decisions have error in them. Certainly not saying their job's easy, but that's a dangerous position for a veteran to be in, knowing that 75 to 80% of the decisions the board makes are going to be in error. And you're going before a board hearing, you want to make sure that you're prepared for that hearing and present the right evidence. So I want to put together a nice, solid presentation on what you can do to prepare for your BVA hearing, and we'll get that released here. I haven't decided if I'm going to do it as a video webinar type setup or if we're going to do it in writing or not. So let me know your preferences. Shoot me an email and let me know. That'll kind of factor into the decision, but I want to make sure it's thorough. Ricky C. had a question about how to service connect sleep apnea secondary to other conditions. Listen, that's a big question that a lot of veterans are asking. And so take a look at the links to the sleep apnea field manual, as well as the sleep apnea training package. I cover this throughout the blog in several posts, so I'm going to defer to those. Links to all those are going to be in the show notes so that you don't have to hunt around for them. Just use those show notes. It'll be in the first comment below this video once it's posted. So after we're all done recording live, this video will be recorded and you can watch it. Alan H. had a question. What are some internet resources for locating medical specialists for opinions? That's a really good question. And there are some things that you can do in order to find a medical expert, a private medical expert. So we all know that there's a couple of doctors that just kind of float around through veteran circles, and every veteran is using them, and the VA sees that. And so these folks get reputations as hired guns, and as a result, their opinions are not looked on as favorably as other examiners. So there's some things you can do to find a qualified, competent, and credible medical opinion for a VA claim that's not a VA doctor. I'm going to talk to you about some of those methods. That's another great full-length video that we can do, and I can show you what my firm does in hunting down experts. But we'll do a whole video on that topic. So I've got 3 more questions that I'm going to go into great depth on, but before I do that, I want to tell you, one of the things about video that I've always been hesitant to do this is the fact that sometimes this information can go stale. So what does that mean? So down the road, the VA may change its rules, may change its regulations, may change its process, and this video is still floating out there, and veterans may be watching it. And because it's a video on Facebook, it's going to be very popular. Facebook likes to promote these videos because they think video is the way of the future for Facebook. So we've got information out there, the possibility that it's going to go stale. What I want you to do is anything that I say in this video, I want you to go ahead and research it and do your own research to verify what I'm saying. This is recorded October 21st, 2016. And if it's any more than 30 days, there's a good possibility that something in here might have changed. So do a little bit more research to make sure that you're finding out the information is still up to date. Let's jump in on the first question. So this one comes from an anonymous veteran, and he says, I got a 10% rating for PTSD, and I think I'm entitled to at least 30%. I asked my VFW VSO rep, who told me not to appeal because the VA will reduce me. So wow, okay, and that's a real common thing to hear, unfortunately. And before I get into this, I want to say I have nothing against VSOs. I'm a big believer in Veterans' Choice, not the Veterans' Choice Act crap that they passed earlier that's kind of putting everybody in a pinch, but real Veterans' Choice of their representative. So for years and years and years, the VA had a rule that didn't allow you to hire an attorney to help in your claim. So if you were charged with a crime in this country, you could hire an attorney. If you were charged with some violation of an immigration law, you could hire an attorney. Frankly, if you were charged with tax evasion, you could hire an attorney. But if you fought and bled for this country up until 2007, there were some pretty strict limitations on when you could hire an attorney. So in 2007, that law changed, and now veterans have a choice. You can choose to work with a VSO, and there are some really good ones out there. There's some bad ones out there, too. A lot of bad ones. You can hire an attorney. There's some good ones out there. There's some bad ones out there. You can also do it yourself, and that can get dangerous if you don't have the knowledge and the information and the power to be able to do that. And so what's really important is that you make a good choice of your representative. So throughout this talk, I'm not bashing VSOs. I do have some significant criticisms of some VSOs and some of their practices, and we're going to get into one of those right now. But I don't want any impression that I'm bashing VSOs. I don't believe in that. I don't believe in that at all. I don't like it when attorneys are bashed, and so I don't do that to VSOs. But the bottom line is this. Here's what it comes down to. If you are disabled because of something that happened in military service, you either are or are not entitled to a certain level of rating. In other words, you have certain symptoms. The medicine, the doctors, the medical records, your lay evidence all demonstrate what your symptoms and what your limitations are. And so it's defined, it's concrete. You've also got 38 CFR Table 4, which lists the impairment rating criteria for that condition, and they're defined and they're concrete. So you have two defined concrete things, and a representative's job is to match those two things up, see where they match, and then argue the highest rating that you're entitled to. So when somebody comes into our office and says, I think I'm entitled to a higher rating, that's what we're looking at. We're looking at how does their condition impact them today, compare that to the impairment rating tables, and we make an honest, no BS assessment whether we think we can prove it. And if we can't prove it, we tell them. We say, listen, I don't think we can prove that. If we think we can, a lot of times we offer representation. VSOs, a lot of times, are telling folks, I don't know, if you try for that 30% on PTSD, they're going to take away the 10% that you got. Or if you try for 100%, they're going to take away 70%. I mean, take a look at anybody in this, listening in on this live thing right now. I'm sure that somebody here has heard that from a VSO at some point and has been discouraged from filing an appeal because of that. So that's a big problem. You are either entitled to the rating or you're not. And so when somebody tells you not to file an appeal when you think you're entitled to a higher rating, and they tell you not to file that appeal out of fear that the VA is going to reduce you, fear that the VA is going to retaliate, fear that's going to do something, the VA is going to do something to you, you need to question whether that representative really truly is thinking about you or whether they're thinking about themselves. And what do I mean by that? What I mean by that is that I had a message just pop up on the screen. I was worried that we're going to lose our connection here. So if I do, we'll come back to it. But what I mean is that a lot of times, and attorneys use this same excuse too. So this isn't limited to just the VSOs, but attorneys will tell you this too. And I think, frankly, that it's the coward's way out. That attorney, that representative, the VSO does not want to tell you that they don't want to work with you anymore, and so they come up with this reason. Now, the problem is that reason is probably true. Listen, the VA is very retaliatory. They talk about a non-adversarial system. This is the most adversarial system that I've ever worked in, and I've gone up against the FAA in employment cases. I've gone against the Postal Service, who is notorious for fighting tooth and nail on every single workers' comp claim that's ever filed. I went against the Dallas Independent School District several years back, and they dug their heels in, but nothing was as adversarial as the VA, so I challenge that belief. But they are retaliatory too, and we've got examples of them retaliating against veterans who speak out. Their own employees that blow the whistle are subject to retaliation, so much so that Congress has to look into passing another whistleblower law to stop that. So it's a very real fear that if you file an appeal of a rating, that you could get reduced. Now, the VA is supposed to send you a letter in the mail saying we're going to propose to reduce you to XYZ percent, and you're going to have theoretically an option to either continue collecting your disability compensation payments or not until it's decided. Here's the thing. If you decide to keep getting that money while the VA is investigating whether or not to reduce that rating, if you keep that and they decide to reduce it, then you're going to owe them all that money back. If you say, hey, I don't want to receive my disability compensation until we resolve this, if they end up keeping it the same or increasing it, as can happen, then you'll get the past due benefits. So that's something that you want to consider. And frankly, some folks may not want to for the very reason that we discussed here. They may not want to deal with the VA anymore, and so they may not appeal for that reason. But just be careful when a VSO or an attorney or anybody is telling you not to appeal a legitimate rating that you think you're entitled to, as long as you think you can prove it and you have the facts and the medicine to back you up and you know what you're doing, or your advocate knows what they're doing and they want to represent you, there's no reason you can't win that. It's going to take time. That's the thing in the VA system. It's often speed versus accuracy. So the accuracy of the benefits is often, you're going to sacrifice speed. If you want a fast decision, if you want something fast with the VA, I can show you how to get something fast, but it ain't going to be anything near what you deserve, and it ain't going to be anything near what you want. You can get a real fast 0%. And frankly, there's not anything really wrong. There's a whole post that's going to be in the show notes about 0% ratings. But in any event, I was actually talking about this very issue, this idea that a representative might suggest to a veteran, don't appeal out of fear of getting reduced by the VA. I was talking about this on Facebook. I was chatting back and forth with the National Chief of Staff for the VFW, Kaelin. He was a little bit shocked to hear that VFW reps were telling folks this. And so he gave me some information. I'm going to share that with you. If you have a VSO with the VFW, the Veterans of Foreign War, if that's your VSO, and they tell you not to file an appeal that you're entitled to out of fear that the VA is going to reduce you, I'm going to give you a toll-free number that I want you to call, and I want you to tell them the name of that representative. And Kaelin, the National Chief of Staff, has said that he will look into that himself or make sure that that is happening. If you don't get any feedback, let me know, and I would be more than happy to follow up with Mr. Kaelin. But here's the number right here, 1-800-VFW-1899. Now, that's their main number, but just reference the fact that you have a complaint about a VFW representative. Listen, if this happens near as much as I see it happening in C-files, their phones should be ringing off the hook within about 10 minutes, right? Because every single one of us has heard of a veteran that's been strong-armed into not pursuing a claim or a benefit they're entitled to out of fear that the VA is going to take away what they've already got. We already feel powerless enough in a lot of situations. We're taught learned helplessness by the VA, and adding that onto it, it's just a fear tactic that while there's some legitimacy to the concern underlying it, it's a fear tactic that's used to motivate something that I think is improper. So hopefully that answered your question. The bottom line is, if you think you're entitled to a higher rating than the VA gives you and your VSO doesn't want to help you, start taking a look at attorneys. Start thinking about doing it yourself. There are also accredited agents out there who are non-attorneys. There's very few of them that know what they're doing. But there are some really, really rock solid ones and some really rock solid ones that follow this blog. So happy to introduce those to you if you shoot me an email. But look into another type of representative. You have that choice. You have that right. Take a look at it. All right, so there's that question. As we're starting to get some more people coming in here, getting some questions popping up. All right, yeah, that's true. There's a post in here. My experience with VSOs in Houston and Richmond, Virginia, are that they aren't knowledgeable and have incentives that do not align with individual veteran needs. And that's very true, unfortunately. And that's kind of the way the VSO system is set up. These organizations are set up to do probably something more on the national lobbying level. And I think a lot of times the claims and appeals is an afterthought. I don't know if that's how it was intended to be, but that's kind of what it's become. So a lot of legislators up on Capitol Hill are scared to death of the Big Six: DAV, VFW, American Legion, Paralyzed Veterans Association, Paralyzed Veterans of America. They're scared to death of them because they have big membership bases. And so whatever those VSOs tell the legislators, they listen. Now, what's happening, though, is their membership is declining, a lot of these big organizations, because nobody wants beer halls anymore. The fastest growing veterans group in the country is Team Red, White, and Blue, which is a group of veterans and non-veterans that get together on the idea that getting outside in the outdoors and exercising, running, walking, hiking, climbing, biking is good for building community and morale. So the bottom line is those big six are weakening in their power. And if you also look at the BVA statistics, they're losing appeals a lot more. And I'm going to post about this next week. I think we had some stuff earlier this week up on the blog about this. But right now, as it stands, attorneys have surpassed VSOs when it comes to appeals. Attorneys don't do a lot of claims work because the VSOs have kind of boxed them out there. You don't have the right to hire, well, you do have the right, but you just don't have the right to pay an attorney for your initial claim. You can't pay an attorney to help you until you're denied. That's crazy. It's kind of silly. But the bottom line is, if you file an appeal to the BVA, your likelihood of a successful outcome is 50% higher with an attorney than with a VSO. The reverse is true. The likelihood of a bad decision is almost a third higher with a with a VSO than with an attorney. So just be mindful. What it all comes down to in the end analysis, it's not attorneys versus VSOs. It's making the right choice. There are some rock solid VSOs out there, some awesome ones, and I've met some of them. Some of these folks just dig and dig and dig until they find the evidence. Some of them dig their teeth into the VA and don't let go. Some of them give good advice, walk their clients, walk their veterans and their survivors through this process and explain it to them along the way. There's some really, really, really good ones. There's also some bad ones that just file some paperwork and then go home for the weekend. Same thing with attorneys, frankly, too. You know, there's mills out there that just take veterans' cases without looking at them and then just wait for the VA to grant them and they churn the fees. It's out there. Everybody knows it's out there. The VA knows that they're out there. They just don't want to do anything. There's pension poachers out there and the VA doesn't do anything about it. But there's some great attorneys, too, that will, in a lot of cases, kind of go many extra miles to make sure that your rights, not only in getting the benefit, are secured, but also your constitutional due process rights are followed, because that's something this system is largely lacking and I think is going to change in the next 10 years. But in any event, the whole point is make a good choice, because your representative, VSO, attorney, or yourself is what matters. If they're good, they're doing their job, and they know what they're doing, and you have confidence in them, and they're getting things done for you, it doesn't matter what they are. They could be a rock for all I care. Probably not going to work out too well if they actually are a rock, but you see my point. Anyway, talked enough about this. Let's move on to question number 2. Will filing an appeal delay my claim? And will filing a new claim delay my appeal? All right, so there's one scenario that we know for sure, that if you file a fully developed claim at a VA regional office, an FDC, if you file one of those and then you turn around and you file an EZ form with another claim, or if you file an appeal of another denial, that claim that you filed as an FDC is going to get bumped out of that process. So in that scenario, absolutely by rule, you're going to be delayed. All right, but frankly, there's a lot of other scenarios where you could be delayed if you file an appeal. So largely, is it because you filed the appeal or because you filed the new claim that caused the delay, and nobody has any idea? Nobody has any idea what the case is. So listen, in most cases we don't know. The VA has, I don't know, it's like 18 or 19 different computer systems to handle veterans benefits, and some of them date back to the 1990s. Well, actually, one of them dates back to the 1980s. One of them is still built on DBase, which, if you guys remember DBase, that was the rage, in 1992. It no longer is used pretty much anywhere except probably, in making fun of computer technology from 35 years ago. But in any event, look at this. Here's a list of the computer systems that the VA has: BDN, Virtual Mail Portal, CACI and SMS, VBMS, Capri, CEST, Covers, Iris, MAPD, PCGL, Shares, VACLs, VBMS, VONAMS, Virtual VA, SEP, eBenefits. Who the hell can keep all that straight? That's already 17 systems right there. None of them talk to each other properly. None of them can relate information. None of them can keep up to date with information in the other one, and it's just a massive Charlie Foxtrot. And so there's a lot of confusion when you file a new claim and you've got one going, or you file an appeal and you've got a claim or appeal going. There's a lot of confusion about what that does to the others. And listen, here's the deal. When you're making the decision, you kind of have to weigh, and I mentioned this earlier, speed versus accuracy. If you are looking to get the benefits, the full array of benefits that you're entitled to, and you have the ability to wait, it's always better to file as soon as you believe that you're entitled to the benefits. And you file an appeal as soon as you believe that you have the evidence, or at least have the solid enough argument to prove up that appeal. And don't wait, and don't worry about what's going to happen in the VA claims process. On the other side, if what you really want is a fast decision, then you're going to have to start playing this system a little bit. And start playing and timing your appeals and timing your claims. And in fact, that's why I don't have any hair left, is because I've been trying to do that for our clients, and we're largely successful at it. There's a lot of cases that we're getting done in under a year. There's a couple others, frankly, that have been sitting on for 3-4 years, and those are the ones trying to find loopholes in the system to get these things pushed through faster. It's caused my hair to fall out. But in any event, that's really the criteria that you want to weigh, is speed versus accuracy. Which do you prefer? And frankly, I'm of the mind that what's most important is getting the benefits that you're entitled to, no matter how long it takes. And sometimes when you have tougher claims, time can be your best friend because rules change, regulations change, they get liberalized over time, new presumptions come in. And so generally the old sage advice that you hear from some of the old timers is just keep that thing going. It creates a backlog, but unfortunately, the system being built the way it is, that's what we have to do to protect ourselves. Some other factors you want to consider in deciding whether to file an appeal while a claim is going on or filing a new claim while you got one going on, and the timing of that, consider the strength of your case. How strong is your case? And all of us, frankly, every single one of us thinks that our claim is strong, we're going to win, it's proved. I called a client the other day, and I started out the conversation, we were prepping for a comp and pen exam. And I started out the conversation with him and I said, listen, the big thing that we have to prove still is service connection. That's the missing element. And he launched into a 15-minute dialogue about how he is service connected and how he absolutely certainly is service connected. And I was like, I'm not going to mention his name. I believe your case. That's why I took it. That's why I'm working your case. But the bottom line is that the VA doesn't believe that. So we have a perception of how strong our cases are. And sometimes we need a little bit of objectivity to see that the VA doesn't see it that way. And I'm not saying that the VA is right. What I'm saying is when you can see the case from the VA's perspective, you get a whole different look at it. So in any event, the strength of your case is an important consideration in whether or not you're going to file an appeal while you have a claim going on or a claim while an appeal is going on. Also, how well can you prove up the claim? If you can prove up a fully developed claim and you have confidence in your ability to do that, then you might want to hold off on that appeal until it gets really close to the deadline if you think you've done a good job, because they're supposed to be doing those in 125 days or less. And by and large, they're hitting that goal with the fully developed claims because, frankly, who couldn't issue a decision in 4 months when you don't have to do any work, when it's done for you? If you want to file a fully developed claim, I've got a training program on the website, how to file a VA claim. We're actually going to be updating that here in the first quarter of next year, but right now you can watch that training and get a real thorough idea of what other veterans have done to file fully developed claims, to do it successfully. We've got one vet that emailed me and won almost $250,000 in past due benefits using that. He told me it was hard work, and that's how I know that he followed the instructions in that course, because it is hard work. Nothing in life that's worth doing is easy. But in any event, my thinking when it comes to juggling time, when do you file an appeal? When do you file a claim? Is it going to slow down one or the other? Should I request my C-file because it's going to slow down my claim? That's another common question. You just got to decide what's best for you. Is it getting the right kind and amount of benefits no matter how long it takes? Or is it getting something now and letting the rest sort itself out later? That's a dangerous and risky proposition. Us attorneys are real risk averse anyway. So just consider that. That's really, unfortunately, it's a horse trade, speed versus accuracy when it comes to the VA. There are ways to speed this thing up, though, and I share a lot of these on the blog. Whenever I find a new method, I share it with you. We've got one post on there. If you've filed your VA-9, you've gotten your appeal certified to the BVA, and I think it's 2014 or earlier, you should be filing a motion to advance that for a hearing on the docket. And I've got that all explained in the post on the blog. The link will be in the show notes. I've got a template for the motion to advance that all you got to do is fill in the facts that are relevant to your case and your situation, file it with the BVA, and in most cases they're able to get, if you have a financial hardship, a medical hardship, administrative delay, and some other grounds, then you're going to get an accelerated hearing at the BVA. Another way that's not well known, I've written about this on the blog, and I'll put the link in the show notes, that there's a way to, the post is titled 3 Ways to Win at a DRO Conference, but there's a way to use the DRO Conference to shave 1 to 3 years off your appeal time. And I teach that in this particular blog post. I'll put a link in the show notes. So anytime I find tools and tips, there's a host of them on there. There's a whole ton of them on there. Those aren't the only 2. But they're on the blog. I share that information with everybody so that you have access to the same things that I do. When I filed my first claim back in 2007, this sort of information wasn't out there. And because it wasn't out there, I didn't know where to go. I was an attorney, and this claim boggled my mind, the claims process. So it wasn't, these resources weren't there. Once I started through that tunnel, I decided that I wasn't going to turn the light out on the veterans that were coming behind me, and so that's how this blog largely got its start. But anyway, let's move on to question number 3. And this one comes from Delvin M. I'm going to grab a sip of water because I've been yakking. All right, Delvin M asks, what do you do if you disagree with the effective date that the VA has assigned? There's 2 choices. You appeal is the first choice. I'm going to go into detail on that. Or you file a Q claim. Now, Q claims, that word is kind of thrown around like candy when it comes to VA benefits and appeals, and everybody thinks, oh, the VA did something wrong, you file a Q claim. No, a Q claim is a very specific type of claim. Frankly, I shouldn't even be calling it a claim because the court has come out and said that it's a motion to revise a prior decision based on clear and unmistakable error. The VA, on the other hand, just ignores that and wants to call it a claim. But in any event, here's what you do. When you get your VA ratings decision, you're either going to have upstream or downstream issues. The upstream issues are the first 2 pillars, your eligibility as a veteran and the elements of service connection. That's upstream. Once you've proved that, then you've got to prove what the court calls downstream elements, and that's your impairment rating, how badly you're disabled, and your effective date. Okay, so when you get a VA ratings decision, it's usually going to either deny service connection, and then it's not even going to talk about those downstream issues, or it's going to grant service connection and it's going to rate you and give you those assignment of those downstream issues, the effective date and the impairment rating. And you're going to look to that to appeal if you don't agree with it. If you don't agree with the rating the VA gave you, you want to look to appeal. If you don't agree with the effective date, you want to appeal. All right, and you have 1 year from the date of the notice of action letter attached to that ratings decision. Now, that gets tricky because there's often different dates. So you got the VA ratings decision and then the letter on top of it. Sometimes it's the same day. I've seen them as far as 3 years apart, believe it or not. So you have 1 year from the date on the notice of action letter, but I don't usually wait till that date. I usually file it 1 year off the ratings decision just so that I'm sure. But you got 1 year to put together that appeal. That's a lot of time, and then it's not a lot of time. Because life happens, and so it can get really hard to prove up what you need to prove up or assemble all the stuff that you need to prove up in a year. But you're going to file an appeal, you have to follow several steps. The first is to file a notice of disagreement on VA Form 21-0958. That didn't used to be a requirement. To file a notice of disagreement, you used to only have to say, I disagree with this decision and I intend to appeal. That's all you had to do. Now the VA came out, I think it was March of 2015, came out with a requirement that you got to fill out this form. And frankly, I think it violates due process because a whole host of reasons. But the form basically seems to force your arguments into this little tiny narrow box. But file that form. We attach continuation pages. I've got some templates that are on the blog. If you get on there and search for notice of disagreement, I got a 45-minute or 30-minute walkthrough video of one explaining how they work. I've got templates that you can use for a notice of disagreement. Once you file that notice of disagreement, the next step that the VA is going to have, and I'm assuming you're not requesting a DRO, that's another conversation for another day, the VA is going to send you out an SOC, a statement of the case. All right, once you get that statement of the case, I've got a whole walkthrough video that explains that. I'll put the links up in the show notes, but walk you through a statement of case to show you how to really analyze one. You've got 60 days to file a VA Form 9. Once you get that VA Form 9 filed, then the VA has to certify it to the board, and that's when you sit in line waiting for your board hearing. So nice non-adversarial process, right? Yeah, that's a bunch of nonsense. But that's how you appeal generally. Now there's a lot of tricks and tactics that you can do in between there to shorten that time. There's some things you have to put in those documents in order for them to be legally sufficient, so it can get a little bit challenging. But if your decision giving you an effective date is less than 1 year old and you disagree with that effective date, file a notice of disagreement and appeal it. Okay, some folks are going to tell you out there, oh, file a reconsideration. I'm going to tell you, we got a court case right now where we're dealing with this, where it wasn't a VFW, I'm sorry. There was a VSO that trapped our client into, he wasn't our client at the time, but they trapped him into this reconsideration and had him file some confusing language about withdrawing his appeal, and that's largely what the issue's about. But they tricked him because there's no such thing as reconsideration at the regional office level. The first time that you can seek reconsideration of a decision is at the BVA. And you can also seek reconsideration at the Veterans Court, but at the regional office there is no rule or regulation that allows you to seek reconsideration. So don't do it. You know, there's posts on that. I share my opinion on that. Others disagree with me, but I have yet to find somebody that has done that and not gotten boxed in. I talked to a veteran at a conference recently that, you know, they basically said you've got to get that, if you're going to do this reconsideration, you know, the whole idea is that they're going to delay it until the notice of disagreement is past due or past its 1 year, and then they deny it, and then you don't have time to appeal. So that's kind of the trap. But in any event, that's the first thing. If you got 1 year left and you disagree with your denial of service connection, you disagree with your impairment rating, or you disagree with the effective date that the VA has assigned, file a notice of disagreement, start the appeal process, okay? Option 2, if that time has passed, okay, and this is going to get a little tricky because Q claims are complicated, you're going to look to file a motion to revise for an earlier effective date in a prior VA ratings decision based on clear and unmistakable error. That's a mouthful. We call it Q. So basically how it works is this. You've got that ratings decision that's, you know, over a year, 2 years, 3 years, 5 years old, and you've lost your opportunity to appeal. But within that, there's clear and unmistakable error. Basically, it works like a claim to reopen, but then it doesn't. So you're going to file this motion, and you have to specifically argue what the error is, why it's clear and unmistakable, and how the VA should have known that was error. And it's really complicated. The elements are a lot more difficult than that, and I've got some posts. I'm going to put them in the show notes that you can read about Q. The Veterans Court has given us some real clear guidance on Q claims, and they are a challenging way to go. But if you have a ratings decision where you disagree with an effective date and you don't have time to appeal, that's really the only option that you have. So that hopefully that answers the question. There, I'm going to put all the posts that I referenced will be in the show notes, which is going to be in the first comment under this video after it is recorded and posted on Facebook. So, in any event, we've had some folks dropping in, dropping out. I wonder if this DDoS attack is interfering with folks because we didn't have the highest participation as we did last week. But in any event, if anybody out there listening, I'm going to stay on for a couple more minutes. I'm going to yak about coupon codes and whatnot. If you have a question, post it in the thing here, and I'll be able to type it in and hit enter, and I should be able to see it scroll up. I've got time to take a couple of live questions. If you want to purchase a membership to the Veterans Law Blog. I'm going to give you some coupon codes through October 26th. You can either get 10% off of a monthly membership or $10 off an annual membership. And those coupon codes will be in the show notes. It's only good through October 26th. Here's a question. I just need an advocate looking for a rep through benefits. Says no one within 100 miles of you. Heck, Atlanta's only 86 miles away. Yeah, I hear you there. Listen, bottom line is, if you're going to, I can't speak to VSOs. VSOs largely are attached to a particular regional office, and often they share office space in the regional office, and they're real chummy with the raiders, and there's some horse trading that goes on there. But largely, VSOs will only work with one regional office, and so you are kind of limited there. And when you go into e-benefits and search for an advocate, you're only seeing VSOs. You're not seeing attorneys. There's a whole host of, there's 450 attorneys out there that are active in this practice of law that don't show up in e-benefits. And there's a reason for that, and there's a reason that the attorneys are battling to get into that list so that veterans are aware of it. But go to vetadvocates.org. That's the National Organization of Veterans Advocates website. And there's a member directory on there. And there's over 450 attorneys that are in that organization who are regular practitioners in the area of VA benefits law. Start making phone calls. Most attorneys when they start out doing this restrict themselves regionally just because they're trying to keep costs of travel down and those sorts of things. But as you get more and more years under your belt, most attorneys expand and work anywhere in the country. So some limit themselves regionally just by choice, but you're not stuck with an attorney just because they're close. You don't have to choose a close-by attorney. In fact, I've got clients that have lived overseas. We had one client that lived in Thailand for many years. I've got clients that I've never met because we do a lot of our stuff electronically. So don't let that geographical limitation hold you back when you're looking for an advocate. Again, the most important thing is that you choose wisely. And not to sound like Yoda or something like that, but the bottom line is I've written a book. It's going to show up backwards on your screen right now. I think it is because the way the camera is set up here. But I'm going to walk you through. I think it's almost a 60-page book here that I'm going to walk you through how to choose an attorney. If that's the choice you want to make, how to make a good choice of choosing an attorney. What to ask to make sure you're not getting some newbie that doesn't know what they're talking about. What to ask to make sure you're not getting one of these mills that really doesn't care about your case or claim and it's just sitting there waiting for a feature. And I'm going to give you all that sort of information. I'm going to talk to you about what questions to ask to find out if they regularly practice, if they're experienced and knowledgeable, if they're connected to people in this practice area so that they know about recent developments. So, in any event, the book is available. The link will be, you can get the hard copy. You've got to pay for the hard copies, unfortunately, because I have a publisher that does it and I can't control the cost there. But the ebook is free on the Veterans Law Blog website. If you want to do an ebook version, then you can print it out yourself. The links will be in the show notes. So here's another one coming up here. There was a question there about FOIA. It scrolled off my screen, so sorry I missed that one. This one started a queue request about 2 years ago, and the paperwork still hasn't been worked. Looked at my file, and there are sticky notes still on it. What next? Man, I tell you what, that gets tough because the VA is in no rush to adjudicate Q claims. When it comes on the totem pole of what's important to them, generally speaking, the claims that the VA is most focused on are the ones that Congress is investigating them for, frankly. I mean, I hate to be crass and whatnot, but that certainly is what it seems to be. So if Congress is hot around the collar for Agent Orange exposure claims, then all of a sudden the VA seems to churn those out. If Congress gets kind of wrapped around the axle about traumatic brain injury issues, then all of a sudden that stuff starts working itself out. But way down on the totem pole after survivors are Q claims, and there's no duty to assist in a Q claim. So there's largely not a whole lot you can do. There's one thing you can think about doing. I would encourage you to be cautious about this because it has some very specific requirements. But if you've been waiting for a long time and you feel you're being denied a right to a remedy, when I say a long time, I'm really talking over about 18 months on a Q claim. You might want to look at a petition, or if you have a medical hardship and you're in your terminal illness, last days or last year of your terminal illness, or if you've got an extreme financial hardship, then you might want to look at this option as well. But it's called a petition for writ of mandamus to the court. A writ of mandamus basically is asking one court to order a lower court or agency to do what it's required to do by law. Now, I think in reality, the Court of Appeals for Veterans Claims, maybe, I think I can count on one hand the number of times they've actually granted the writ and ordered the VA to do something. But what happens is a lot of time the VA says, oh, wait a minute, this writ's been filed, so they will go ahead and adjudicate the case or claim or the appeal and take the next action so that they can come back and say, oh, look, court, we did it. You just mooted the petition for writ of mandamus. Arguably, I don't think you do, but that's a more sophisticated argument I don't have time to go into here. But the bottom line is you might look at the posts on the blog about a petition for writ of mandamus. Be very careful with that, though, because the Veterans Court is kind of on a seesaw when it comes to writs, as they're called. There are some judges that seem to think they are a good thing. There are some judges that abhor them, that hate them. And frankly, I think it's only a matter of time before somebody gets sanctioned for abusing the writ process. I've just read enough of these decisions to start seeing some of the tone change. I talk about that in one of the blog posts about a couple of decisions a year ago where two judges are kind of going back and forth. I have no idea if they were actually, communicating to each other through these competing decisions, but if you weigh them against each other, they're very opposite sides of the spectrum, we'll say that. So be very careful at the court. You may want to look at hiring an attorney to help you with a petition for writ of mandamus. Problem with attorneys doing that is that if the VA moots it, by taking the action, they're not entitled to attorney's fees. So again, it's kind of one of those catch-22s. What's the old Bible saying about, you gotta don't muzzle the ox that's treading the corn, and that seems to be the thing that's going on a lot of times when the way the VA and the courts interfere with your ability to hire an attorney is they just find a way to cut off their attorney's ability to get paid for the work they do, to eat the corn they tread. And so it leaves veterans kind of without any real representation. So that's another gripe for another day. But look at that petition for writ of mandamus. Here's another question I can do real quick. What time we got? Let me see. Oh, we got a few more minutes. All right, the request was from an effective date change. I was moved from 70 to 90, but it was only paid for 4 months versus the 36 months. I'm going to have to take a look at that post. I'm not sure I understand it. So I'm going to have to take a look at that, and I'll get back with you. Oh, we just blanked out a little bit there. All right, here's one more question. This is a good one. I received a sleep apnea machine 7 years ago on active, so will I have any issues with the VA? I hear that question a lot. Listen, the key thing in any claim, it's not getting a sleep apnea claim, it's not getting a CPAP. The CPAP is an important thing for your treatment, and it's also an important thing for a certain level of benefits. But whether or not you're granted service connection has nothing to do with a CPAP, okay? What it has everything in the world to do is when were you diagnosed? When did your symptoms appear? What's the cause of your sleep apnea? And tying it all back to service connection. And there's 4 common scenarios that occur. I talked about this, I think last week. I talked about those 4 scenarios in one of these video Q&As. I also cover it on blog posts, and I talk about those 4 scenarios in the sleep apnea field manual. But they all turn on when you're diagnosed, what type of condition you have, and what the symptoms when they first appeared were, and what the causes are. So that's what you really want to focus on in a sleep apnea claim, is those things right there. Once you get that service connection established, then that CPAP becomes important, because you're going to be eligible for a 50% rating if you use a CPAP to treat your sleep apnea. Now, the VA has come out in April of 2016 with this real odd new regulation that first it does one thing really good, is it says you don't just have the opportunity to use a CPAP to get a 50% rating. If you're using one of these dental devices that are used to treat sleep apnea, that's qualifying for a 50% rating as well. So that's a good thing. The bad thing that they did is they said that now to get entitlement to that 50% rating, you need a proof of medical necessity of a CPAP machine or that dental device. Well, they weren't specific about the dental device, but you need a medical necessity statement from your doctor. And I kind of question that, because I don't think there's a whole lot of doctors out there that are just saying, yeah, let's just give you the CPAP machine. I don't think it's necessary, but take this big hunk of metal and wear this thing all night. Just see how it turns out. It's not necessary. That's a bunch of nonsense. Doctors don't prescribe things unless they're necessary, right? Especially a machine like a CPAP machine, which is a huge investment of cost for the VA, as well as for all the contractors that monitor those machines and make sure that they're operating properly. So you can read about this reg change on the blog. I post about it. It's a little bit disconcerting to me. We haven't seen a lot of cases trickle through with it yet, so we're not entirely sure how it's going to work out. But I give you the safe man's perspective on what to do in that situation. So, in any event, listen, guys, I am going to sign off for the weekend. I think I've covered everything that I have to cover. Let me look at my notes here real quick. Yep, I think we're good. Thank you for taking the time to hang out. This video will be posted live, or not live, it'll be posted as a recorded video up on the Veterans Law Blog Facebook page, and we will embed it into the blog later next week. So if you have any more questions, shoot me an email at support@veteranslawblog.org. If you have any questions about what I said, or if you have any ideas of things to talk about in another video, we'll be back next week doing the same thing. So y'all take care, have a great weekend, and go Dodgers.